Okay, Judge, we're live now.
Good afternoon. This is Judge Alyssa Perez presiding over the 210th District Court Criminal Docket for January 25th, 2022. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Pantoja, will you call our next case?
Yes, Judge. Cause number 2021-0D0-3011, State of Texas versus Juan Antonio Rodriguez. Announcement to council, please.
Roa King for the state of Texas.
And Eduardo Solis for Mr. Juan Antonio Rodriguez.
And Mr. Rodriguez is appearing from the jail annex. Mr. Solis, do you recognize your client?
Yes, I've met with him last week and I see him there.
Okay, perfect. Okay, so we were scheduled for an arraignment today. However, I think this was one where I just wanted to schedule it quickly when we could all be here, because last week it was set, Mr. Rodriguez, your case was set at a time where I did not have access to bring you into the hearing, okay? And so that's why I kind of did it very quickly, just so we could all get on the same page. I can tell you I've just received, thank you, Ms. King, the motion from Mr. Solis. So Mr. Solis, I don't know how, but she sent it over to me. So you can, your office, she took care of it for you. So I'll be signing off on the order with respect to the investigator. Excuse me. But I understand we may just need, do you think maybe another week, Mr. Solis, or what do you have to tell the court?
All I need to address the court about is that Mr. Rodriguez wanted to make sure that I was in fact a defense lawyer assigned by the court and not some other individual trying to learn something about the case, or I'm not sure what his skepticism was based on, but I wanted him to know that I am in fact appointed by the court. I wanted Mr. Rodriguez to know that I've moved to appoint Mr. Jorge Mijares, who is also present. If you could raise your hand, Mr. Mijares, that he is an investigator with my office. And so I wanted Mr. Rodriguez to know that we're ready to move. All we need to know is whether he is comfortable with me being his court-appointed lawyer or not.
And maybe I can give you a little more information so you know, Mr. Rodriguez, you were initially appointed, I believe, by the jail magistrate, the public defender's office. And when a representative, I don't know if he's here today, he's not assigned to this court, was here last week on your behalf, they had filed a motion to withdraw because there was a conflict, because they handle so many clients, there was a reason that they could not represent you. So I granted that withdrawal, knowing that I now could appoint Mr. Solis. So I did appoint Mr. Solis to represent you. As I mentioned, we were set for an arraignment today, but typically those are done by waiver. If you don't want to do it that way, Mr. Solis, then I would say that we have to at least set for 1 week to give you an opportunity to meet with your client, to review the indictment. But are we, I don't know, in a sense, good to go, or is there something else outstanding for now?
I'm good to go. I guess it depends on what Mr. Rodriguez's sentiments are about this.
Mr. Rodriguez, do you have any input?
We're good to go. Yeah.
Okay. All right. Then I will wait until we get probably past the arraignment and into maybe one more setting. I don't know if we discussed it all, Mr. Briggs. Did we discuss it all? Anything, you know, do we know of any significant outstanding discovery, things like that? I mean, we're very early on, but I don't recall having discussed that last week.
I don't think we did, Judge, and actually, I'm not here on this case. Ms. King.
Oh, I'm
is
sorry.
on this case.
I'm sorry.
No, that's okay.
Mute.
I know
Ms.
a little
King,
bit. Know a little bit about it, but
Okay, sorry about that. You're closer to my box on this screen, so I just looked over at you, but I need to look at Ms. King. All right, I'm sorry, Ms. King.
No problem, Judge. No, we have not. But I will get with Mr. Solis and to go over kind of the discovery, timeline and a breakdown.
And it's very early on, and I know we have our trial schedule, but I'm going to keep these, so I'm going to keep these settings. I would like them at 3 o'clock docket, unless Mr. Solis, you are okay with waiving your client's appearance for other settings. We'll go by your gauge, okay?
Right. And as soon as I visit with him, we'll get that waiver of arraignment signed, and I'll tell you what his position
Okay.
is.
All right.
Bear in mind, I've only been on the case 5 or 6 days, so.
Understood. I understand.
Okay.
At least
All
we're
right.
on track now. So
Okay.
I will sign off on the order appointing and then we can go from there. We'll see you all next week, okay?
Thank you, Your Honor.
Thank you very much. Thank you, Mr. Rodriguez. Who's next?
Thank you,
Chief?
Your Honor.
Okay, Judge Vaughn with Miss Arditi. Miss Arditi, are you ready?
Yes, Your Honor, yes, Chewy, yes, we are ready.
Yes, ma'am. Let me bring up your client now. Annex, if we can get Priscilla Vaughn, please. Priscilla Vaughn.
Okay, Chewy, go ahead.
Yes, ma'am. It's cause number 2021-020-1580. State of Texas versus Priscilla Vaughn. Announcement, council, please.
Roa King for the state of Texas.
Your Honor, good afternoon. Regina Arditi on behalf of Mr. Vaughn. And Your Honor, this is my motion, and it's a motion to withdraw.
Okay, you may proceed, ma'am.
Yes, ma'am. I have filed my motion to withdraw in regards to Mr. Vaughn. I have found it extremely difficult to be able to communicate with him. I have indicated to him what the plea recommendation is.
What is it, Miss Arditi?
It is 8 years TDC.
Okay.
I have tried to explain to Mr. Vaughn the situation. He does have 4 pen packets. He wants, and I understand, he wants credit for time served and he wants to get out of jail. But he has been in jail for quite some time. He's been in there since May 2021. So he does have over 6 months, Your Honor. But that is not something that I had been able to come to an agreement with the previous ADA. I had brought that up to Mr. Vaughn. He has sent me some extremely disturbing letters, Your Honor, threatening, and I just feel I can no longer communicate with him and cannot represent him. So I'm asking the court to allow me to withdraw and for the court to appoint someone else.
Okay, so we've gone beyond, we have a jury trial set in March. What is outstanding, other than our settings, what is outstanding, Mr. Arditi? We have any motions that require a hearing? Was there anything, motion to suppress, anything like that?
Nothing like that, Your Honor. I had filed my 2801 motions. So my motions have all been filed.
Okay.
However, I did not send them for a hearing because I personally did not feel it was necessary, and I'm not about to waste the court's time. But Your Honor, based on those letters that Mr. Vaughn has sent me, he has asked me to withdraw, and he has also threatened me. And I think that is totally inappropriate behavior by any.
Mr. Vaughn, I just need to ask you a very simple question. If you'll just answer that question, are you in agreement with Ms. Arditi's request to withdraw?
Yeah. Yes,
Okay.
ma'am.
All right, then, Ms. Arditi, let me just make sure. We have a final judges conference on February 10th. Chris, we need to put that at the 3 p.m. meeting.
Yes, ma'am.
And then our jury trial is set for March 11th. Just for your benefit, Mr. Vaughn, I'm letting you know, because of COVID, I know we just had a temporary stop or cancellation of trials. So just know that that situation is very fluid. We don't know the way COVID is. We don't know from one day really to the next whether we're able to go to trial or not, but you are set, okay? I'm cautioning, it's tough sometimes to get to our trial settings. I try and get panels, but if we are stopped, it may mean a delay. However, I am granting her motion to withdraw, and I am going to appoint Joshua Spencer to represent you. He will receive that order today and will be in contact with you. We're coming back in less than 2 weeks. So if what we're looking at is a trial, we will work on getting the trial date secured. And if there's anything outstanding, Ms. Arditi has filed several motions. I don't know if Mr. Spencer will want to reevaluate and, go forward on any of those, but we'll work on that. But we'll be back on that February 10th setting at 3 p.m. I'll tell you this though, Mr. Vaughn. I don't know what the real basis of your dissatisfaction is with your attorney's representation. I don't know if you're just not happy with the offer that the state's making, but I will not put up with you threatening anyone. I'm not saying you did or didn't. I'm not going to get into an argument with you about it, but we're not going to have that. Do you understand me?
Yes, ma'am.
All right, we'll see you on the 10th. Thank you, Ms. Arditi. I'll go ahead and sign the order.
Thank you, Your Honor. I appreciate it. And may I be excused, Your Honor?
You may. Who's next, Chuy?
Thank
Okay,
you.
Judge, Ivan Corral on page 4. Annex, if we can get Ivan Corral, please.
Good afternoon. Mr. Pantoja, the daughter tells me she's in the waiting room.
She's coming in now.
Okay, thank you.
Yes, ma'am.
And Chris, if you have that order on the motion, on Ms. Arditi's motion to withdraw, if you'll email it to me real quick. And as I say that, I bet you Ms. King will go get it. Don't do
Okay, Judge, I'll get it to you. I'll be
Thanks.
raw.
that. All right.
It's a race.
All right. Is this Ms. Corral? Go ahead, Chuy. Or are we waiting on someone?
No, the daughter is on as well, Judge.
Okay.
Ms.
Let's go.
Brianna Garcia. Cause number 2018-0D03475, State of Texas versus Ivan Corral. Announcement of council, please.
Robert King for the state of Texas.
Julia Martin on behalf of Mrs. Corral, Your Honor, ready to proceed.
Ms. Corral is appearing from the jail annex. This is one, I believe, this is the one we had this morning, right? We were able to get her. So thank you, Annex, for getting her to be here today. We were waiting, and I believe your attorney represented Ms. Corral that we have. Is it Ms. Garcia? Who has the monitor for Ms. Corral?
Your Honor, I've been advised that her boyfriend has the monitor. His name, I believe, is Art Leos. Is that correct, Ms. Garcia?
Yes, Ms. Corral.
Okay, yes. It said her
My
daughter's here.
Yes.
I've been coordinating a lot with the daughter, but yes, he does have the monitor, Your Honor.
Okay, so Ms. Corral, you picked up an additional DWI, and so at this point, we're going to modify your probation to include this monitoring device. Let me see. I'm going to need a report. Shoot. I'm going to need a report on her within the week. So Carla, can you make note on there that I guess I want at least a month of weekly reports on the monitor to ensure compliance. Ms. Corral, I'm telling you this right now. If you're not compliant with that monitor, you're going to end up right back where you are right now. I understand you have a lot of family issues and things going on. Do not fail to comply with the monitor and any of the other conditions. All right?
Yes.
Your attorney worked very hard, and it sounds like your family is working with you as well.
Yes.
Carla, also on on any permissions or requests to travel, those need to be submitted ahead of time. Ms. Corral, I understand that possibly you have some family members out of town that are going through some medical issues.
Yes.
You cannot leave unless you get my permission. You understand me?
Most definitely, yes.
All right. So we'll do that, those weekly reports, Carla, with that modification, and she's good to go to be released. I think the motion, we need to have the dismissal of the motion. Okay? All right.
Judge, I have a question.
Your Honor.
Hold on, one at a time. Go ahead, Julia.
Your Honor, your voice faded towards the end, so I did not hear your last sentence. Is she going to be released?
She's going to be released.
Thank you.
That
Sorry.
was going to be my question. Judge, do you want me to do an order to release the streets?
Yes.
Okay, sounds good.
And Ms. King will get me my dismissal.
Yes, Judge.
And within a week, we'll know if she means to be on the right track or not. All right? Okay. All right. Thank you very much. Monday.
Before we're excused, if I may, I know we discussed this in the morning regarding her
60-day jail ACOP days. She will have the credit for whatever time she has in there, and then she'll have the remaining balance from the 60 to take care of before her probation expires.
That's correct. So you're gonna find out, Ms. Corral, from probation, how much you have left to do, because you still owe us time in jail.
Yes.
So find that out and get it done. Alrighty. Thank you, Carla. Yes, that was one other thing. What else?
Thank you, Judge.
Takes a team.
I'll call her at the jail right now.
Thank you very much. Thank you, Julia. All right. Thank you, Ms. Corral. Who's next?
Okay, Judge, Crystal Guillen, page 6. Annex, if we can get Crystal Guillen, please. You're good to go, Ms. Garcia.
This is a 2022 case? Oh, wow. Okay. Mr. Hernandez, is this yours?
Yes, Your Honor.
Good afternoon.
Good afternoon, Your Honor.
Okay. Go ahead, Chief.
Yes, Judge. It's cause number 2022-0D00012, State of Texas versus Crystal Lynn Guillen. Announcement of council, please.
Carla King for the state of Texas.
Edward Hernandez, on behalf of Crystal Lynn Guillen, we're ready to proceed, Your Honor, and I believe this is a hearing on our motion for bond reduction.
It is, and your client is, you see her, she's appearing from the jail annex. Mr. Hernandez, you may proceed.
Yes, Your Honor. Your Honor, Ms. Guillen is a lifelong El Paso resident, a United States citizen. She's a certified nursing assistant, a single mother, although currently non-custodial. She resides at, and by non-custodial, I mean, she doesn't actually, she has the type of like shared non-custody, Your Honor. She resides at the Inspira Hotel, but not because the court placed her there, but because that's where she's actually a lessee. So that's on the far west side of town. The complaining witness is on the far east side of town, Your Honor. We have no, there'd be no problem with keeping a no contact order. Your Honor, also, we've received a message from the complaining witness who said that her injuries were very minor, that she didn't want to go forward with prosecuting. We see that the state does not have a rec yet, or at least didn't have as about an hour ago when I last checked. My client does telework from home, Your Honor, so if released, hopefully she still has her job or can get another type of telework job that she can do from home, so she wouldn't have to be traveling to where the complaining witness is. Your Honor, we also, we're okay with a no contact order. As the court knows, I am the mental health advocacy and litigation unit attorney in this court. And my client would agree to comply with the continued mental health services and medication, Your Honor. With that, we would pass to the state, but we'd ask the court to, we're requesting a full PR bond, and if not full PR, to lower the cash bond as much as possible, Your Honor, because I believe currently it's at about $285,000.
Yeah, that is that all for our case? I mean, that's what I was looking at, Mr. Hernandez. It's not like a cumulative, that's an odd number.
Yeah, I thought so too, Your Honor. I got no idea what it is.
Okay, give me a second. Anything else?
At this point, Your Honor, I'll respond to whatever the state has to say.
All right, Ms. King, go ahead.
Your Honor, the state respectfully disagree to granting a bond. So what we have here is an individual who is actually has picked up an assault against the same victim, which happens to be her mother. It started 2017, 2018, 2021, and here we are again. This happened, the officers were dispatched to a stabbing. We have had contact with the victim's mother, and she has stated that the victim does have, or the defendant, I apologize, does have some incompetency problems, which is why I went ahead and I updated the rec on portal for the defendant to be screened for competency. It's also alleged that the victim also told us that she's off her medications. And also, ADA Renee Flores, I believe he handled her bond hearing. So he does have some input as well.
All right.
Your Honor,
Mhm.
I did handle the defendant's bond hearing. Mr. Hernandez, were you there for that?
I was not, Your Honor, although I believe, and I don't usually make this objection, but I don't usually see it either, for two counsel to represent one side at the same time, Your Honor. I believe one or the other can be the attorney on the case, but they can't both be the attorney on the hearing, Your Honor.
Okay, so you're objecting to Mr. Flores being part of this bond hearing?
Well, Your Honor, it's either one or the other, but it can't be both. I mean, unless we can double or triple team on both sides.
All right. So, Ms. King?
Your Honor, this is just an uncomfortable to have an individual that allegedly she is diagnosed with schizophrenia and she's been off of her medications for a while. Even though she currently does not reside with the victim, her mother, it's been the same victim for the last 3 cases. And at this point it's more.
It's not true.
All right. Well, I would like to hear from Mr. Flores regarding the previous bond hearing. Go ahead, Mr. Flores.
Thank you, Your Honor. And Mr. Hernandez, I do respect your objection, but I just did want to inform y'all of that last hearing that we had with the JMAG, Your Honor. She was represented by the public defender, and she became abusive, and it was incoherent speaking on her part. This is an issue that we
Your
have.
Honor, I'm going to object to that as well. That's
Let me go ahead and stop. So I'm looking at the bond. So it was, because there were what, 4 counts? 3 counts? It was 200,000 that was on the ag assault, 10,000 on the theft, and 75 on the evading with a vehicle. Did I hear, is there a motion for competency out there, Mr. Hernandez?
not on my part, Your Honor.
Okay, I thought I heard that. I just wanted to make sure that was not.
I think
And Your Honor,
state was
and I'm sorry
suggesting.
this is not, we did reach out to I did reach out to Mr. Stevens. We did not know Mr. Hernandez was on the case, but I reached out to him yesterday regarding our concerns regarding their client. And that was merely what we were trying to accomplish yesterday. We did want to speak to Mr. Hernandez regarding his client and her well-being. So that was one of our concerns, not just on the state's part, but just in this case going forward. And I know Mr. Stevens is here, and I see him on the.
So now it's even. Now we got 2.
Your Honor, and I'm going to object to that. There's one attorney for my client, and it's me.
Yeah, and we understand that, Your Honor, but we're just trying to bring a full picture onto this bond hearing, Your Honor.
Okay, what I need to know is, does the state object to, Mr. Hernandez, what are you asking for? A full PR?
I'm asking for a PR bond, Your Honor. I don't know what the state is asking for.
Okay, and the state, are you objecting to?
Yes, Your Honor, we
bond?
are objecting to that.
Are you objecting to any reduction whatsoever?
Yes, Your Honor.
All right, anything else, Mr. Hernandez?
Your Honor, just that obviously early at this stage, I don't want to give my client's defense away, but there clearly is a valid, reasonable defense, which we will bring forth. But for the time being, Your Honor, my client is not objecting to taking any medication, continuing with services. Your Honor, the only issue is can she bond out and stay on she doesn't even have a car, Your Honor. She would be on the far west side. The complaining witness is on the far east side. She needs to work out of her own home anyway. And we would ask for the court for a referral to back to the Inspira, only because I don't know if her tenancy or lessee relationship is still going there, because she's been incarcerated for a month. So she may have to, we'd ask the court to refer her to Inspira, and then she can get her job and start paying the rent again. You know? And again, I would point out, Your Honor, that while the state is alleging that, as to what the complaining witness is saying, the complaining witness has left recordings with us that state that she does not want to go forward, that the injuries are minor, Your Honor. And we'd ask the court to take that into consideration. She clearly does not have a female client, Your Honor.
And Your Honor, we have requested the medical records. So the state has not seen the severity, but this was a stabbing.
She's actually offered us the medical record, Your Honor, complaining witness to say it's really minor.
So I'm sorry, I may have not heard this. What is the criminal history? Is there a assaultive, violent criminal history?
Yes, Your Honor. So in 2017, there was an assault, an AFV with the same victim. 2018, AF continuous violence against the family that with the same victim. Then we have an aggravated assault, family house with a weapon, 2019, same victim.
And what happened to those cases?
I believe those were dismissed.
For what?
Non-prosecution.
I agree with you, Your Honor.
And it's been her mother, Your Honor. And we have, it's all same here. We have the mother who is also saying that she does not want to prosecute, but the main concern for the state is, which is why I have put on there to have her, screen for competency. My concern is more for individuals getting hurt. I mean, for the mother.
I'm not sure what you're referencing with respect to, are you bringing to the court a request to have her evaluated based on your observations?
Yes, Your Honor.
Mr. Hernandez, you've met with your client?
I have, Your Honor.
And you're not having those same concerns?
Your Honor, I am with the mental health unit. I have spoken with my client. I understand her mental health history. I also understand that when she's medicated and being cared for, received her services, she's coherent, she's rational. Granted, I didn't get this case initially. It ended up in this court. It used to be, I think, in the 34th, and that's where the confusion over who the attorney is occurred. But she'd been my client a couple of years ago, before the last case was dismissed. And so I know this client, Your Honor, and she appears rational to me. But that is that's the court's prerogative, Your Honor. I'm not taking a position on that. I'm just asking the court to, they can do an evaluation outside of the context of being locked up in jail, Your Honor. And she, as the state, I agree, is admitting that she hasn't been convicted. Since when do accusations count as something when the cases keep getting dismissed, but these allegations,
Well,
come up over and over.
that weighs into my concerns as well, because what I'm hearing right now is that the state is opposed to any type of bond reduction, but we've had a pattern of, and I'm not saying she was guilty or anything like that, Mr. Hernandez, but they dismissed all the cases that are supposedly bringing all this concern. So I am not sure I have enough information right now well, no, I do. For the bond, I do. The bond request is denied. The bond is going to remain at $285,000. What I do have a concern, though, without interacting myself with your client, is I'm not hearing from the state that, I don't know, as she stands here right now, there are questions about her competency. I don't know if when she was first booked, and I don't know when that first bond hearing was, if that situation has been stabilized. So I do want to revisit this, because if that concern is here, Mr. Hernandez, I know you will inform the court so we can follow that process. I can't ignore what the state is saying, but I also know she's probably a month away from the last time. Is that about when the last bond hearing was? When was the last bond hearing?
Your Honor, I'm looking that up right now.
It looks like the indictment came down on January 6th, but I don't see another. Let me go. Yeah, I don't see a notation for a previous bond hearing. It was probably just that 48-hour hearing, right, that they get right at the beginning when they're jailed. And if
that is correct, Your Honor.
If offense occurred on December 25th, then we're probably looking, within 3 days of that, she was at a bond hearing. But I don't know. I'm going to come back on, we're coming back in a few days, Mr. Hernandez, on February 3rd, and then we're not coming back until April 21st. So the denial is going to be based on the prior history, nature and circumstances, future safety of the victim. Yeah. So the bond reduction is denied.
Ma'am, I wanted to go ahead and just speak.
Miss,
Don't say anything. Don't say anything, ma'am. We'll talk afterwards.
Falsified in court. They just falsified.
okay, Miss Guillen, your attorney is
It's a
instructing
record.
you for your own benefit not to discuss anything about your case, okay? Mr. Hernandez, I know is very diligent and will be in touch with you about how you are going to proceed forward. Mr. Hernandez, aside from those issues, if you need to readdress the bond, please file your motion and the court, okay?
Yes, Your Honor.
Thank you, Ms. Guillen. Your attorney will be in touch with you.
Am I excused, Your Honor?
Yes.
And Ms. Guillen, I'll go see you. Thank you, ma'am. Thank you, Your Honor.
Thank you, Mr. All right, what's next, Sherry?
Okay, Judge, Rafael Villanueva, page 7 as well. Annex, if we can get Rafael Villanueva, please.
Yes, sir. It's on up.
Judge, while they're getting the next defendant over at the jail, I don't see Mr. Anderson
Oh,
anywhere
I know,
here
and-
on the screen. And he
and
wasn't
he-
here last time.
Right.
and
Right. Chewy or Chris, let's
Judge,
start
I'll
tracking
give him
down
a-
Mr. Anderson.
Yes,
Okay,
ma'am.
thank you. All right.
Judge,
there's
just so
Mr.
you know, just about maybe 10 minutes or so ago, I tried calling his office, got no answer, and I left them a voicemail.
Okay, we need to find out what's going on because that's not like him. I mean, I'm a little worried actually that something's up.
Well, Judge,
Um,
I do know that from discussions with another prosecutor in the office, there's a very large, very old case that is headed towards trial here very, very soon if Judge Chu's order hasn't upset all of that on a defendant over in the 243rd that's been kicking around for about 6 years that Greg is on, and it's a massive case. So my guess is that that's where his energies have been devoted. But this is the second hearing I'm not seeing him here.
Yeah, I think we
something.
just kind of reset it from last week because it was like, well, we gave him a break then, but something, I mean, I was more thinking of maybe he was out of pocket for some other concern, but no, we need him here, Chewy. So this is the second time that we're having to do this. All right. Or
Yes, Judge.
Chris, sorry, Chris. Okay, let's go ahead and call Mr. Villanueva's case.
Yes, Judge. It's cause number 2020-0D04363. Cause number 2020-0D06556. State of Texas versus Rafael Villanueva. Announcement of council, please.
Roa King for the state of Texas.
Mr. Villanueva for the defendant.
I'm Renato Welsh, and I've been appointed by the court to represent Mr. Villanueva.
That's
Thank you,
correct.
Mr. Villanueva. Please let me take care of this for you, okay?
So let's, thank you, Mr. Welsh. Thank you. We set this very quickly because I guess based on the last hearing, we needed some assistance. Mr. Williams was removed as an assisting attorney in Mr. Villanueva's cases. And so, Mr. Welsh, have you had the opportunity to just give the cases a quick preview in terms of scheduling and prior history in the case?
Yes, Your Honor, we have a request from the court. There are some sealed records in the case, and we've submitted a request to the court to have access to the sealed records. We received a response from the court saying that we had to have the records unsealed, but in fact, the order that sealed the records specifically permits the defense attorney to have access to the records, and we need to get those and share those with Mr. Villanueva so we can go forward.
Okay, is that, give me 1 second, Mr. Welsh. Let me get out of this screen and to your client's screen on Odyssey. I haven't received that in my email. Chris, do you have it?
No, Judge, I don't have those. I had let Mr. Walsh's paralegal know that Marissa had advised that we needed that motion to unseal those records as per.
That's not my paralegal, that's Miss Sullivan.
Oh, excuse me, Mr. Walsh.
She's an attorney. She's not a paralegal. And
I
she-
apologize, Mr. Walsh.
And we don't need to unseal the records to access them.
We just want to ask.
We just want to access them.
I would like to object.
Your Honor. Sorry,
Objection.
okay, hold on a second. Okay.
Objection.
This is, no, Mr. Villanueva, you do not get to object. You can consult with your attorney at a time when we're not sitting in front of the prosecutors. and when he can have a confidential conversation with you. So you need to hold on for a second, first of all.
I think last hearing we had.
Are you not listening to my instruction, Mr. Villanueva? I've asked you to stop talking because multiple people are wanting to address the court.
Right, the understanding was that I was going to proceed.
No,
to
listen to
defend
what
myself.
I am ordering you to not speak at this time. And if you can't hold off, then we will conduct this hearing so that I can address Mr. Welsh and you can step aside.
Okay, I'll call Mr. Welsh to have him withdraw.
Please do, sir.
Okay, I don't even know how many people were talking, but Mr. Welsh, I think, was it Marissa that was chiming in, and I'm still trying to access your case?
Yes, Your Honor. Sorry, I did receive an email from Chris asking about a motion on sealed records, but it was labeled ex parte.
I'm gonna go ahead and excuse myself from this hearing for the moment, and I will be.
Thank you, Mr. Villanueva.
Sorry, Judge, I went ahead and muted him.
Oh, okay, I'm sorry, Marissa. What were you saying? Who's that? Okay, let's everybody take a minute and figure out who's muted, unmuted, and one at a time. I think Marissa was speaking.
Okay, so I had received an email from Christopher about some sealed records, and it was labeled ex parte, so I did respond back that it needs to be unsealed. But if I don't know what records now Mr. Welsh is asking for that don't require the ones that need to be unsealed. So if I can just get clarification on that
pass
one.
you off to Ms. Sullivan, who will explain that.
Oh, okay.
Judge, we were reviewing the cases, and I noticed that there are two evaluations that have been sealed out of the 384th. One, I believe, resulted in a commitment order, and the other one, I believe, resulted in a transfer back to you. And I'd like to see the psych records. I think the order sealing them out of the 384th was my old order, and I think it says that defense counsel can look at them. I'm not trying to unseal them and make them public. I just want to see what the psychological reports indicated.
Does that clear things up, Marissa, or no? And I'm sorry, I think
Okay, I'm sorry. So it's the competency reports from the 384th then?
Yes.
Okay, I can just provide copies of those. Sorry, I thought you said something else. Yep.
So there are two. Yes.
I think what she said, Marissa, is that there was two. I don't remember. Was Mr. Villanueva sent twice?
No, he was sent. Okay, he was sent to the 384th and apparently found incompetent because Judge Garcia signed a first commitment order. And then there was an attempt made to put him into OCR, outpatient competency restoration. And Mr. Villanueva strenuously objected to the conditions that were placed on him in order to be placed into outpatient competency restoration. And so he was restored to the clearinghouse list. At some point, he made a pro se motion declaring himself competent again, having regained competency somehow at the jail. And another evaluation was ordered out of the 384th, and I believe that was Cynthia Rivera's examination. And she found him competent to stand trial, and that resulted in an order in October or so, transferring the case back to you. And I need to see what both doctors saw there, because I don't think we're all seeing the same thing.
Okay. So Marissa, if we could get that to Mr. Welsh. I don't know how you all transmit it, but if you can arrange that. And if there are any concerns, or if it's not what you think, or you didn't get what you needed, please request the hearing. I was trying to go through and look for a motion, but I'm not finding anything. Or
no, there's no motion. An order in the record, and that order says defense counsel.
Okay, so we don't really need it.
So the clerk doesn't image it.
Okay. Okay, so Marissa, can we get those to defense counsel?
Yes, Your Honor. I have two sealed records here. I kind of opened them just to take a peek, and it's from two different doctors. So if this is what they're looking for, then yes, I'll contact them and see what we can arrange for them to pick up some copies.
Perfect. That's usually what we do is hard copy, and then I'll run down and pick them up so that we're not transmitting it all over.
Okay. All right. What else do we have outstanding?
Well, Mr. Villanueva, I believe I'm the fourth or the fifth attorney on the case. And he made some allusion to firing me, but I don't believe he has fired me yet. So I'll continue and we will try and work with him to the best of our ability. I've had pretty good luck with people who are,
In this
challenging. I've been the fifth attorney before and was able to resolve the case. And
without looking, I thought we, at least in this court, we were at number 2. So please do what you can. Our trial setting is in May. What I will tell you is I have scheduled these at the 3 o'clock setting. And part of my concern of making sure now he had court-appointed counsel was that he had indicated at the last hearing that he felt he did not have adequate resources at the jail to represent himself, which had been his initial request. Okay.
Right.
So with that said, I just would like to throw out there, Mr. Welsh, I don't know what you think about this, how useful it will be to have the 3 o'clock settings. Okay, meaning my jail docket. You're set at that time, but honestly, I have concerns about the outbursts and things like that. I understand
maybe we don't need it there. He apparently has some good friends at the jail because they allowed him to use the phone from the library to call our office. Miss Sullivan had more than a half-hour conversation with him. Things were going along pretty well.
Okay.
So hopefully he'll call us again. And
Okay.
I don't know if the only thing he's going to do is come on and say he wants to fire me. I don't know what we need him for. He can always fire me later.
Okay.
And try and make some progress on the case.
And I'm not saying I'm taking him away. I just, if we're just going to be having all kinds of disruptions.
Yeah, well.
Better maybe for him not to be there until we make a
He
decision.
just gets too frustrated, Judge.
I understand. Well, just let me know, okay? Just keep us apprised if things
Well, we'll try and bring those resources to him that he needs.
Okay, so we have our settings. Let me ask you, Ms. King, what's the rec?
Your Honor, right now, I personally haven't put a rec, but I'm keeping the one that's on there for 5 AP.
So it's 5 years probation.
5 probation, okay.
And no contact with the complaining witness.
The complaining witness being the judge of the 171st?
Correct.
Okay.
Okay, let's see how this goes, okay?
Yes, ma'am.
Is there anything else? Anything else?
Nothing else in the defense.
Okay, thank you very much. Ms. King, anything?
No, Your Honor.
Okay, thank you so much. Thank you both.
And thanks for calling, Chewy. Appreciate it.
Yes, sir. You're welcome. Stay safe, sir. Get well soon.
Yes, sir. Thank you.
Next, Tree.
Okay, Judge Adeline Moore. Annex, if we can get Miss Adeline Moore, please.
Yes, sir.
Thank you.
Good afternoon, Judge.
Afternoon, Mr. Stevens.
Good afternoon, Ms. King.
Good afternoon, Mr. Stevens. How are you?
I'm doing well.
Okay, Judge. It's cause number 2021-0D0-1487. Cause number 2020-0D0-5067. Cause number 2019-0D0-6837. And cause number 2021-0D0-2854. State of Texas versus Adeline Leona Moore. Announcement of council, please.
Robert King for the state of Texas.
Brent Stevens for Ms. Moore.
We are scheduled for bond hearings. Okay, there we go. So what is her bond, Mr. Stevens?
Judge, on the probation cases, which are 3 of the 4 cases that were called, there are no bonds. And it's straight probation on each one. There's 10 TDC for 10 AP on the cases ending in 6837 and 5067. And then there's a state jail felony ending in 1487. That one is 2 years probated for 5 years adult probation. Those 3 cases have no bonds. For the new pending unauthorized use of a vehicle with ending in 2854, that's a $5,000 cash or surety. In addition, she's also being held on 2 unfiled cases. There's an unauthorized use of a motor vehicle, which is set for an examining trial on February 3rd. That one is JMAG 21-14969. That one has a $25,000 cash or surety bond. And there's also a failure to identify fugitive from justice misdemeanor with a $1,000 cash or surety bond. That's JMAG 21-14968. So
What are the alleged dates of offenses on those 2?
the 2 unfiled cases are December 10th of 21. And that's per the jail information. I haven't seen the police reports because they're not filed.
Okay, so, okay, what else do you have for the bond hearing?
Well, Your Honor, my client is 40. She's born in El Paso, a U.S. citizen. She's lived here her entire life. She does have a residence to go to if released, and that would be living with her mother and her father. It's in this 24 zip code. I won't give the address over YouTube. She's currently unemployed, has 4 children. They live with her mother. My client has a GED. Also, there are numerous reasons why Takumi EHN referrals would be appropriate for Miss Moore. And she has agreed to cooperate with seeing Takumi if released. So her goal eventually is to move out of El Paso. She wants to live somewhere else in the state, but Miss Moore understands that she must remain in El Paso and live with her mother until further orders from the court allow her to do otherwise.
Okay. Ms. King?
Your Honor, the state respectfully disagrees with the bond. So this individual has an extensive history from the past, and there's actually a motion to revoke that was filed today on the 4 probation cases, and that's to reflect the 2 new offenses that did occur on December 10, 2021. And also, Ms. Moore does have a tendency to not report to probation.
Oh, I know. I am so familiar with Miss Moore. It's sad. It's sad because I remember when we did the plea, it probably took good 20, 30 minutes just to go through the priors that were on the indictment. That's not even like a rap sheet. Miss Pineda, in terms, I was going to look up we had a problem with Miss Moore right off the bat, correct, on probation?
Yes, Your Honor.
And it was just a matter of time. In fact, I think when I saw those bench warrants this morning, Miss Moore, I kept waiting to see when they were going to pick you up, and lo and behold, I guess it wasn't our bench warrant, right? It was the new arrests. Is that what it was?
Yes, Your Honor.
Mm-hmm. So what are the bonds at? We had no bonds, and then I see something like 30-some thousand. Is that right?
That's right, Judge. 31,000 total.
And was she on deferred?
No, Judge, it's straight probation on the 3 cases. 10 TDC with 10 years adult probation, 10 TDC with 10 years adult probation, and 2 years in the state jail with 5 years adult probation.
Does she have any prior pen trips? That I didn't remember. Mr. Stevens, I know you were not the attorney on those previous cases when we were working through them, but I am very comfortable characterizing the way the court was patient and willing to work with your client as almost out of the ordinary, because I extended every bit of help every step of the way, even when she was getting rearrested, even when I was hearing from jail magistrates how they were not in agreement with letting her out, and I was okay because I believed when she told me that she was going to get her act together, that she was going to do it. And then when she pled to probation, I still said, well, okay, maybe. And that meant nothing. Your request. Go ahead, Ms. King.
Your Honor, she does have 2 prior pen trips. That's how we have the 2020 and 2019 cases were enhanced, and they were for theft of property as well.
Yeah. Mr. Stevens, I'm sorry. The request for any reduction is denied.
Okay, thank you for hearing us, Judge, and I'll be in contact with Ms. King probably tomorrow, and maybe we can resolve the cases.
Thank you very much. Thank
All
you,
right,
Ms. Moore.
Judge.
All right, who's next, Chuy? Did we not get Mr. Anderson? If not, and that's the only thing pending, let's take a quick.